You've brought a lawsuit against a doctor who you believe caused you significant harm. Your case now goes to trial. You're on the witness stand, and the defense attorney gets up to cross-examine you. And he turns around and he says, "Hey, Mr. Jones, what did you and your attorney Oginski talk about before you got on the witness stand?" What do you think happens then? The first thing that happens is I get up, I yell, "Objection, Judge!" You want to find out what happens after that? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney practicing law here in the state of New York. I get up and I yell, "Objection, Judge! That's privileged!" Now, what does that mean? It means that the defense attorney is trying to get out information from the injured victim on the witness stand about a conversation that he had with me, his attorney. You should know that any conversations that occur between me and my client are confidential. They're private. They're privileged. So now when I hear that question being asked by the defense lawyer on cross-examination, that he's trying to learn what it was that we talked about, I have to jump up and yell, "Objection! That's privileged information." Now the judge has to determine in a snap decision whether or not what I have said is correct. And in all likelihood, the judge is going to turn around to the defense lawyer and say, "No, objection sustained." And what that means is that the defense lawyer cannot ask that question, and Mr. Jones, the witness, you are not to answer that question. So now he's got to ask a different question. So why does that happen? It happens because of the relationship between attorney and client. Anything that is said during the course of our discussions are private and confidential and cannot be disclosed during the course of trial or at any point in the litigation. So, even though he tried to ask the question, the first thing I have to do is jump up, make my objection known. The judge then has to rule on it. And then once he's ruled, he's going to tell the defense attorney, "Move on, it's the wrong question to ask, and Mr. Witness, do not answer that question." So why do I share this great information with you? I share it with you because some defense attorneys try to get out information before their lawyer has an opportunity to object and before the judge makes a ruling. So now he tries to get some information from somebody who's not paying attention. You know, I recognize you've got questions or concerns about your own particular matter. Well, if you're contemplating bringing a lawsuit for an accident matter or medical malpractice or wrongful death and you have legal questions, what I encourage you to do is pick up the phone and call me. I can answer your legal questions. You know, this is something I do every single day and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a great day.